Kessel Ato Forson Edina Court, Nina, and say, yes, wabo omaine ka 2.37 million euros. Na Dr. Kessel Ato Forson through the proceedings, I said, Dr. Kessel Ato Forson etimi ekokopie mu ewo Court of Appeal ono ekoye appeal na Dr. Kessel Ato Forson na lawyer for aye appeal 2 times. First one ya na second one we there e come here say Ay3su de ama Dr. Kessel Ato Forson na yenja first one or the kokopie mu court court no ebogu and the second one there baby a nneɛma akeka akɔ ne deɛ sɛ Dr. Kessel Ato Forson na lawyer for anhwɛ yie deɛ a ebia afiase ɛbɛbɛm. First one no ɛne deɛ he ɔsɛ the Court of Appeal has in unanimous judgment thrown out an appeal filed by the first accused in the fake ambulance trial, Dr. Kessel Ato Forson, in which he alleged that the charge brought by the Republic against him were defective. Dr. Ato Forson had contended before the Court of Appeal that the charges of willfully causing financial loss to the state and intentionally misapplying public property preferred against him by the state were defective for failing to disclose sufficient particulars. However, in a ruling delivered on 8th June 2024, the court constituted by Bright Mensah J.A. presiding Batel Kojo J.A. and Amaliboba J.A. dismissed the appeal as without merit. Nti Dr. Kessel Ato Forson de kokopie mu ewo court sɛ kwadu no a ɔman no de abɔ no no sɛ ɔno ɔtena ase a ohun sɛ kwadu no a ɔman no de bɔɔ no no ɛnya adeɛ sɛ ɛno ɛyɛ defective. Nti sɛ nke betumi anka Court of Appeal ɛnhwɛ na nka yɛntimi ngyae asɛm ne deɛ because ɔno onim sɛ asɛm no ɔnyɛ bɔne bia ɛwɔ mu nanso ɛkɔpie mu ɛwɔ Court of Appeal no wɔn nso ɛtena ase ɛna ohun sɛ Dr. Kessel Ato Forson asɛm no a ɔde bɛto wɔn anim no ɛnya adeɛ sɛ nsuo biara egyina mu nti wɔn dismissal appeal no as without merit. Dr. Kessel Ato Forson ama no anso hɔ a ɔsan ɛkɔɔ so ne na lawyer for ASA. The appellant Kessel Ato Forson had initially filed an application at the High Court seeking to strike out the charges and failing to disclose sufficient particular to warrant the trial proceeding. The High Court dismissed same. Followed the dismissal, lawyer for Ato Forson filed an appeal alleging, among others, that the High Court judge erred in holding that particulars of offenses of count 1 and 5 contain sufficient information on the specific act engaged in by the first accused or appellant that manifests without the cause and authorization as contained in count 1 and 5 of the charge sheet. The appeal came on for hearing and was vigorously contested by the Attorney General, represented by a principal state attorney, Richard Jambibi, who argued that the Republic has discharged its obligation required by law in putting together the charge sheet. He contended further that in drafting the charge sheet, they had in mind only the alignment and elements of the offenses with which the accused are charged, as the Republic was required to do. Until Dr. Kessel Ato Forson, yɛdi nkan eturo baako no ɛtɔ twene ɛna wɔn ɛsan faale baako ɛde koko pie mu ɛwɔ the High Court ɛno nso High Court no ɛsan ɛbɔ to gu ɛno koraa deɛ na ɔsɛ kwadu no a yɛde bɛbɔɔ no no nka ebi wɔ hɔ a nka yɛnyim firim because na kwadu no ɛdɔɔso nanso High Court ɛka sɛ nsɛm na Dr. Kessel Ato Forson na lawyer for san de aba High Court no ɛka me sɛ no nso ahoɔden nim ɛno nso High Court no nso etimi ɛbɔ ɛde to twene. This they had done, and therefore the charges preferred against the accused persons were proper. The Republic, according to the Court of Appeal, broke down the charges brought against the accused persons before concluding that the charges were properly filed. The Court of Appeal, in its judgment delivered by Battles Kojo J.A., analyzed the rules of the Court of the Appeals as well as Ghanaian case on what constitute a proper charge. The court observed that in the appeal brought by Ato Forson, the problem he had with charges was with an expression without due cause and authorization. The court stated that it was of the opinion that it was wrong to isolate phrases or words contained in a charge sheet and claim that those words are vague or do not contain sufficient meaning. It is one of the cardinal rules of interpretation in our profession that documents should be read as a whole when being interpreted. The court held that with this in mind, what the appellant should be concerned about is Kessel Ato Forson between August 2024 and April 2016 willfully caused financial loss to the Republic by authorizing irrevocable letters of credit valued at 3,950,000 euros to be established out with payment amounting to 2,370,000 euros were made to Big C General Trading Limited of Dubai for the supply of vehicle purporting to be ambulance without due course and authorization, and Kessel Ato Forson in 2014 in Accra, in the Greater Accra region of the Republic of Ghana, intentionally misapplied the sum of 2,370,000 euros being public property by causing irrevocable letters of credit to be established against the budget of the Ministry of Health in favor of Big C General Trading Limited, Dubai, for the supply of vehicle purporting to be ambulance without due course and authorization, and not just words without due course and authorization. Having examined the charges under scrutiny, the Court of Appeal finally held that the charges brought against the accused persons in fake ambulance trials contain sufficient particulars as required under the Article 19, Clause 2D of the 1992 Constitution and Section 112, Clause 4 of the Act 30. Dr. Ato Forson was represented by his lawyers, Dr. Abdul Basit Aziz Bamba. Intimino Elkasedi Elkamia is a high court. And so in some Dr. Kessel Ato Forson at the court
2.37 million euros ambulance case. I met Dame in Kolondi's house, Jakpa Ena Aka. Now, okay, can story now, go on. I send row call to Kudia dance here. I say, Oshia go for Dame. Ewat justice, Yoni Kolondi fee and pre-9. Nani kind Oshia no. Or no na a request here. On send no press conference no more no. O man kind of chromos Dame and a request meeting.
I feel by was saying.
I feel more say Poadumochri a show a screenshot of we no a request for meeting no. I feel the coach na court no or say or no na a request first meeting with Attorney General. Na or requesting meeting because no person Oceano na or church in Simu chair said they be ya or betting semase.
Na ese kenya boni.
O de me ba.
Okay.
Go down. O say go for dame ehia without your lawyers. Na ebu emra so say obi wo e wa asem wo court na other side dey pesi ehia na ese ne lawyer e wo ho ansa na yetime ehia no. Enti dame abu mra so eno ka ho kranti NDC for say Dame on resign. But today, you have told the court, say, I wo and I would to suffer Dame near the kind, so person wouldn't share without your lawyer. And Adame Kokosia. And Jade, so I've been papa. I didn't the one country lawyer say, or no, and Fred Dame, now only in Kosia.
Okay.
But to suffer Dame, a Siano without your lawyer.
Inti, almost say, Japan ujiri di enye
Debi
because story e said nketia ebeka na bonti Japan e ka kire no
yes
and e said nketia abekasa te se comical you know about be and e court no Japan abekasa ono and what to no nsa frɛ
on the to no nsa
efa attorney general
so pane chew
obeso ohia no
in fact odana say attorney general na boa no ma na nya bail
enti sisi on se ka kire mo say enema ekoso wa bonte de se diketa mo ye no ye no de kokko yi
yes
on say asem no one fine one court
yes
kokko na kokka asem no kre
akoka no kre
ama before then na wo kana plan what so expose no we team so me say wona requested
meeting first
ye ka kire mo say go freda me asem na aba no monto bobo
yes na onim
no kre be daddy
onim ni ntia request or introduce ne ho say eye me Richard Jakpa Justice Yoni Colon the Supreme Court judge ni nua
enemy
and me person me share
yeah no crazy so
and I say says what can say dia and no dear so person who share me wo nua no ho dia me arrange through nua no na me share
okay
enti ansana obe share Jakpa no odikan
e ka kire Justice Yoni Colon
obi afrɛ me say ni nua no no person share me wo ho
enti de ba be share wo
enti e ampa na o say ai okay o ni mu bi asan na say ndi ko share wo na me ko share wo
let's say
na eyobu a
exactly
go fredame
exactly
e wo ma Justice Yoni Colon enti no ko ni fi e ko share Richard Jakpa and na ho na me question e ba say enti adenti e na Supreme Court judge no Jakpa Ndra according to the court proceedings no say o share attorney general ho empre 9 ni nyina wo Colon fi e bi 9 p.m. it be 11 p.m. It be 10 p.m. and pre 9.
Welcome, Pacho. A bit more at our home. I say, hey, now could should be 10 p.m. near the idea. Sremo. A be a we teacher me. To my 8 and 8 to 2. No upon. If I want extra classes, it open one ube coffee. But don't forget the teacher. The also or extra class bear 4. Ube do fi now akobono.
Yeah.
Ghana ye want to meet somebody at 10 p.m. and yet out of ordinary.
No, especially in one kind of Kumasi.
Yeah, the one kind of Kumasi. I feel no been part of 1.5 o'clock.
Yeah.
About to traffic, more base, it will be I don't know what you have.
In fact, Obi correct me point regiment because Otu a traffic obeshi fu.
And yes.
I born 9 and son were 2 so good.
Kwakutwaso.
Enti goron obua papa no obuo owoma Supreme Court judge no. Ene ma okukusia no. Na me masem ne say e ba ne sen e na Supreme Court judge asem wo court na a criminal case na ye di asem wo afiase na wo tena asem no so wo fie anadwo 10 p.m. empre 9
okay kwaku
na o de ti o Jakpa say attorney general ka kire no oni no agree e wo Supreme Court judge no efie ho say o de ne ho beche no enti omoa no o de Jakpa's account na make you
okay
enti omoa ono attorney general no na onfa ayi Ato Forson entum na obeja no enti se o man adanse di ni wi a obe submit submission of no case na wa mano no prosecute ni waja no but eduru ho no wanye nti wanye ni nti eno okan wo court say and oni me ahia na do oni me iso no the tape ya ba abontin enti attorney general enta no prosecute ni dia aka Jakpa no yidin
aka media to force it
to force into mu aka wa mekasa
we team so okoton Ato Forson
sa no person he's a person ordinary obi di bg free
obeton the daji kosua
no aka obeton the freedom tio when wo bra judge no akwa kosia attorney general mu fie ena na bopo say mo beboa no according to Jakpa na ni account na mefa
yes
mo beboa no na de Ato Forson atum na wagyawo
na what did you abontin
na de wagi wani na wo hu say ka bia case na ekọ no enya ade ye beba so no ena fe dia oba abontin ebisu me question mi Supreme Court judge no godon ade nti no guso because has media it is said justice sewa afia sarebotwe ma men dem gini dio so timi frɛ Justice Yoni Colon wadaka mu
kwaku bi pacho won't me friend that won't me friend no that be the Ghana judicial system no judge ntimi emfrɛ obi sa that be prosecutor
and so friend no
and obeso mo friend say ABI person
yabodi
but judge no won't me to emfrɛ obi
okay and the prosecutor no can change judge say obehia justice you ni colon e wa dakam na anadwo 9 p.m. ni 11 p.m. no nkoma e course wo ni fie ni ntu no fresh
and say nkoma no say asema ajakpa e ka no say beye nti wahye what you say na ba be his word against the word of Godfrey and I said the word of
Attorney General
no of the chief judge of the Supreme Court Johnny Kulendi na said who be here so bebe mu a obeba ba me de me gidi say Justice Johnny Kulendi asem no ebi ebekọ judicial council me sare me gidi LTA say ho na ebekọ amabi amako kase gbosa say na wo ye Supreme Court judge na say asem ba si wo busu ani say din yo wutimi frɛ wutimi di asem no ebeka asem no bibi ye ni asem no wutimi ebedi asem no nkomo ewu fie
ama wo kyerɛ ba bi asem
no fa nko ana eti ye no de me gidi say I was say judicial council they should take judicial notice of it. Yes. Now, ABS will be a petition. No, said the Quembe Faso no. I'm not sure this will be petition answer because maybe be a reported a equal publication. Me ye frame me.
Wa bro bianco ba money. And you were so I don't know more Casa was me.
Ah, and Tiano dear, so almost a bibiaco bonia or mon freno. Na or mon bakwaku Godfrey Dame. Say Obabe victim office me can say crumple offers respect to the elderly and people of reputation and yes sir ekwonko
kono krankasa and because of sir premise no
yes
I almost said here and ntinema o entertain Jakpa on the telephone
and was anko kan say en yenko hia wa ha o say wo bra na dia
na wo super social media
and me catch no that's what we press why ba bi o no ani fi
asem no ani
so what you see
but no asem no ani
and na bi say dia san ye nwanwa e wo say end this vote be paga na fo nyina actually say o mo twa ntro ato Attorney General so
mebre
Attorney General according to Muamu Richard Jakpa say or no and or to is afraid
Godfrey Dame esre ne say opposition
meanwhile mom na be kana bonte say Godfrey Dame and the tata Richard Jakpa so opposition court so
I say omushia
ba ko voice no
oh
so what dia
so according to quasiability logic any idiot can go to court but there is a note of caution. The courts do not interrogate suspicions, conspiracy theories, conjecture and rumors. They deal with facts, evidence and law. Case closed for the year. So according to quasiability logic, any idiot can go to court, but there is a note of caution. The courts do not interrogate suspicions, conspiracy theories, conjecture, and rumors. They deal with facts, evidence, and law. Case closed for the year.
When Abdul Malik Kubako, and I'm watching Kano, and a deputy attorney general. Try boa say almost 30 say state no start say or ye cross examination not na dance di no e di e face o mo a afi na funu ne bebie amagana fu nyina hu ne bekoso enti entrance emobi antum futu ngu ani emobi a na dawo na asem ne de imbeba hopa me ba cho high sense for asem kan chiro say afi de Euro 2024 no aso Bola can see some pet na TV one here. Obi on one pet TV a chikwan da or crown smartphone. Be do say bobo say peno be a pet TV a chikwan. Ghana should you be any. Say open smart TV. Na open sound system. I'll be sound the gum. Na commentary cost na uti dia. On outside high sense on na koto TV baby a de boom. Ube tu si katran. Into TV pa say a year ye kwakoboy. Say open state of the art. Any high definition TV 4K, any QLED, any mini LED TV, and only are there 32 to 100 inches. At 100 inches in the go ye a board them one at Senior Stadium hobby.